I'm Alan Tannenbaum. I'm here with my partners, John Lamole and Cindy Hill. We're going to be talking today really just about a few pieces of legislation, of the many pieces of legislation that the legislature has passed in Florida that impact community associations. We probably could do a full day on all the different aspects of legislation that has passed or will shortly pass. But today we're going to cover two areas, which is the impact of tort reform on community associations, the good and the bad. And we're going to talk about construction defect claim reform, which is, there's no good in it, there's only bad in it from our perspective. But the tort reform was kind of a mixed bag. One of the things about the current state legislature, it's been true in the last 2 years, they're very productive. There are years when there's really just a handful of significant bills passed. The Florida Legislature is a very active, ambitious legislature, and we have a very active and ambitious governor. And they've given the lawyers a lot of work to do. Every legislative change brings up the need for a lot of opinions to be provided by lawyers as to what to do, and then it sets off rounds of litigation to try to understand and apply what the legislature did. So we are definitely in one of those places. So I'm going to turn the first part of the program over to John and Cindy to talk about tort reform. John, the floor is yours.
All right, thanks. I've heard it said that this tort reform legislation, and by the way, for those of you that want to look it up at home, it's the section I'm talking about is contained in House Bill 837, I think, which was signed by the governor maybe towards the second half of, towards the end of April. But I've heard it said by quite a few people that this is probably one of the most I'll say significant or major pieces of tort reform in Florida over the last 50 years. So it's a pretty significant piece of legislation. It has a lot of wide-reaching effects. We're going to focus on how it may affect community associations like condominiums and homeowners associations, co-ops. It does impact outside of those areas. So I don't want you to think that it's strictly a community association issue, because this really affects, for example, we'll start with talking about the statute of limitations for negligence claims, which has been cut in half. And that impacts a lot of things: slips and falls, trips, auto accidents, and those can happen on community property. They can happen out at the supermarket. I mean, there's a lot of different ways that negligence cases arise. So let's start with that, the statute of limitations for negligence actions. You just heard me talk a little bit about what negligence cases are. Let's be real clear. Negligence under the law is an accident, for the most part, if I were to put it in the most common terminology. So auto accidents, trips and falls, somebody has a slip in your parking lot, or somebody is driving in your parking lot at your community and has an accident, and which may cause property damage to the association. Those are the types of things that are being discussed or being limited in terms of how much time those claims have in order to be brought in circuit court as litigation. So prior to this bill, to this new law, the statute of limitations for negligence claims was 4 years. So you had 4 years from when the claim accrued, which is typically in a negligence case when the accident occurred. That's that. I don't want to limit it entirely to that, but for our purposes today, so that you understand, the basic context of this, you have an accident. You have 4 years under the old statute to bring that claim as a lawsuit in circuit court. Well, that's now been reduced to 2 years. And so significantly shortened amount of time. And the act was effective as of the date that it was signed by the governor. So for any action that is filed after the effective date of the statute, when it was signed by the governor, again, I don't remember the exact date, but let's say it was, sometime in late April last month. Any action filed after that is theoretically governed by now a 2-year statute of limitations. What did we see from that? We saw a rush of lawsuits being filed. Lawyers knew this was coming, or sensed that this was coming, were concerned about it. If they had cases that were longer than 2 years from the date of the accident to when they were looking at this potential legislation, everybody was rushing out to file their lawsuits. Now, that said, I don't know how the courts are going to decide if an accident happened before the legislation was passed, and then the lawsuit is filed after. And let's suppose that accident happened 3 years ago. That's probably going to be something that the courts are going to have to unpack as to whether or not that change in the time period applies to claims that accrued or arose before the statute. But we don't know the answer to that. That's something that's going to have to be settled in court. So for the purposes of you managers and you board members, let's look at this from 2 perspectives. Let's suppose somebody slips and falls on your property, and they trip because of a condition that exists on the property. There's uneven pavement, there's a hole in the sidewalk or in the pavement, or whatever the case may be. There's water on the ground. Then that person who was injured in that accident now has only 2 years to file a lawsuit against the association. Now, associations also sometimes have claims. Like, as I said at the beginning of this, somebody has an accident in your parking lot with their car, they run over, I don't know, they run into the building. I mean, we've seen that, right? There's an old video of somebody driving into the Sarasota airport terminal. But let's suppose something like that happened. Somebody had an accident and drove into one of the, drove into a building and did substantial damage to the common elements of the condominium. Well, the association might have a claim against that person for negligence. And so that is now covered under this statute. And the time limit for bringing that claim is 2 years. So here's the takeaway. If you think that you have a claim against somebody, if you're a manager or board member and there's been an accident, and you think that the association has a potential negligence claim against somebody, you need to pay careful attention to when, this new 2-year limitation, and consult with a lawyer quickly to make sure that you don't find yourself out of time for filing a lawsuit on that claim. Now, I recently came across a case, so I want to differentiate something here because it's an important distinction to make. I recently came across a situation where there was a fire in a unit, and the fire was a result of the unit owner's negligence. And of course, in putting out the fire, there was substantial water damage that was sustained by the common elements of the condominium. And of course, as you know, you have generally fairly high deductibles in the policies that cover your condominium. And so there's a portion of this loss that might not have been covered by the insurance. And so therefore, there's a pretty large deductible that had to be paid as a result of a unit owner's negligence. Now, that may be a negligence action by the association, but it also may be a covenant enforcement action because there may be a provision in the declaration which says that any damage sustained by the association due to the negligence of the unit owner is required to be reimbursed by the unit owner. And so you may be able to avoid this 2-year statute by casting this claim as a covenant enforcement action, which has a 5-year statute of limitations, I believe. So it's really critical to take a look at the type of claim that you may potentially have against, and especially if it's a situation where it's an association that may have a claim for an accident that was caused by a unit owner, or a homeowners association for an accident that was caused by a lot owner. So
John, can
again,
you go to the slide, John, the next slide?
sorry, I'm not paying attention to the slides.
Okay, this is the statute.
This is the statute. So takeaway here is if you've got something that may ripen into a lawsuit because of an accident, it's best to talk to a lawyer, but talk to your general counsel, talk to a litigation attorney, and make sure that you're not missing the opportunity to bring that case.
And just, John, if you go back to the prior slide for a moment, understand that this is all it takes for the legislature. There was a 4-year statute of limitations. They have a bill, they scratch out the 4 years and they move negligence 2 years. And
Right.
there's a dramatic shift all over the state on kind of consumer rights to pursue lawsuits and send all the lawyers into a tizzy with one basic stroke of the pen, having the amount of time that you have to pursue negligence action in Florida. It's fairly amazing the power that a legislature and a governor have to alter the legal landscape on negligence. Go ahead, John. I'm sorry to interrupt.
Yeah, it's pretty simple. Excel and edit somewhere else. Okay, another significant aspect of this bill has to do with criminal acts of third parties and we'll focus here on association property and where those criminal acts cause injury to somebody who's on the property. Now, there's a couple of different provisions in this. Cindy's going to talk about next one of the key aspects of this, and you've probably all heard a little bit about this idea of enacting some security measures and what that would do in terms of providing some relief. I'm not going to focus on that right now. Cindy will get to that in a second. But one of the things that they did is in this section, a newly created section in 768, chapter 768, which says, notwithstanding section 768.81 sub 4, in an action for damages against the owner, lessor, operator, or manager of commercial or real property brought by a person lawfully on the property who was injured by the criminal act of a third party, the trier of fact must consider the fault of all persons who contributed to the injury. Okay, that's a pretty complicated statement there. So let's unpack that a little bit. So what they're talking about here is claims against the owner of property. Now that may be an association because the act occurred on a common area. It may be a condo association because the act occurred in the common, like in the lobby of a building or somewhere else that is comprising the common elements of the condominium. But it technically also would apply to an action occurring inside a unit, an action occurring inside Macy's, the mall, a hotel, anywhere. And what this statute is saying is that even if a person is injured on the property by the criminal act of a third party, right? Somebody comes into the lobby and assaults somebody. And the person who is assaulted sues the association and the person who committed the assault. But let's say they also sue the association because and they claim that the association didn't provide proper security or whatever the case may be. This section now provides that the court, in determining who's at fault and how much damages to award, must consider the fault of all people involved and apportion it accordingly. Now, the reason this is important and the change here is because you see that section that said, or that very first part of this section where it says, notwithstanding section 768.814, 761.814 says essentially that you shouldn't apportion fault for certain types of damages caused by intentional torts. Intentional torts is a legal word for intentional actions, and crimes, criminal activity would essentially fall under that definition of intentional tort. And so, whereas before this new section, certain damages wouldn't be apportioned, now everything is apportioned. And the court must consider the fault of everybody who's involved in that claim, the association being sued, the person who did the act, even the person who was injured, and apportion those damages accordingly. So this is a very important thing. Now, this is going to play into this next section that Cindy's going to talk about, because what the legislature have giveth or have taken away, I'll say in this case, in the next part of this that Cindy's going to talk about, the legislature has given you a way to maybe take it back, or has given you back something. So hold the thought on this, because there's a part B here. So I'm going to stop now. I'm going to hand it over to Cindy. She's going to talk about criminal activity on site and safety and security measures and how that affects claims against the association. And then I think we'll come back to me and we'll talk about some other aspects of this tort reform bill.
Thanks, John. If you could go to the next slide. This is the part that I'm discussing, which is candidly an unexpected act on the part of the legislature as far as condominium lawyers have been watching what the legislature is doing. This was really not something we saw coming, but I see it as good news for associations. This offers some liability potential protection from criminal acts on the property. And again, this is criminal acts. This protection is strictly for criminal acts. It certainly couldn't hurt an association to follow these procedures and use them as defenses for negligent acts as well, but this is for criminal acts. And as you can see, this applies, let's see, I think we got it highlighted here. Yes, number 2 in the new legislation, that this applies to multifamily residential property, which implements these security procedures. And so what is multifamily residential property? It's up here at above number 2 as B. A residential building or group of residential buildings, such as apartments, townhouses, condominiums, consisting of at least 5 dwelling units on a particular parcel. So consult with your association counsel if you have a question about whether you fit into this, but if you are in a building with multiple units, a condominium, you're going to fit into this. So these are security procedures that your association can implement and may well be effective for townhomes for homeowner associations as well. Where if a criminal act occurs on the property and the association is sued for the act, it can turn around and say, well, we implemented these statutory procedures under this new act, and as a result, we're claiming that we're not liable for what happened. And of course, what ultimately is the result of that will be dependent on the facts and the circumstances. But this does give associations a very strong position to be able to say, to the extent someone was attacked on the property or their property was damaged by a criminal act, that if the association implemented these procedures, it has a presumption that it took the proper steps to ensure safety in the community for the purposes of liability. So what are these steps that it can take? Beginning at the bottom of the slide here with number 1, a security camera system at points of entry and exit which records and maintains as retrievable for at least 30 days video footage to assist in offender identification and apprehension. So if you don't already have videos on your property, you might want to consult with your association attorney and follow procedures that might have to be followed to get them set up. I also do see associations that will use videos and then only keep them 24, 48 hours. So notice that 30 days. That is important. The next procedure that an association can follow is a lighted parking lot here at the top of the next slide, illuminated at an intensity of at least an average of 1.8 foot candles per square foot at 18 inches above the surface from dusk until dawn, or controlled by photocell or any similar electronic device that provides light from dusk till dawn. Most of the associations that I work with already have very similar procedures for their parking areas and common areas in terms of lighting. But if you don't, there's some serious incentive to get caught up now. The next one is lighting in walkways, laundry rooms, common areas, and porches. Again, the lighting must be illuminated from dusk until dawn or have a photocell or similar electronic device that provides such light. Here's at least a 1-inch deadbolt in each unit dwelling door. I'm going to get to that issue because it's going to tie into the next one. A locking device on each window, each exterior sliding door, and any other doors not used for community purposes. Here, you will need to consult with your association council, whether you're a homeowner association, townhome, or a condominium, in terms of it's not necessarily a given that the doors are something that are either owned by the association, they may be owned by the unit owner, or maintained by the association, they may be maintained by the unit owner. So implementing those parts of the new requirements for this protection may present some legal challenge, but at the same time, protections that are for the benefit of the community and the safety of the community do rise to a level that makes them more permissible than others. So again, this is a conversation to have with your association attorney on those issues. The next one is locked gates with key or fob access along pool fence areas. If you don't already have as a community some locked gate system on your pool, you are already behind the times. I can tell you that a number of my association have problems with bored teenagers and homeless people getting into their pools after hours. So that is certainly something, if you're not already looking into, here's some incentive to do so. Also related to doors, they say a peephole or door viewer on each dwelling unit door that does not include a window or does not have a window next to the door. That again is going to be a change that could be driven by your documents, but with the presumption that safety always does control. Moving on to the list, they now offer some specific crime prevention assessments you can do. Specifically, the bottom of the slide here talks about obtaining a crime prevention through environmental design assessment by January 1, 2025, and remaining in substantial compliance with that. It discusses how the assessment must be performed by a law enforcement agency or Florida crime prevention practitioner designated by the Department of Legal Affairs. I don't yet know who these people are other than the law enforcement agency. So watch that space. If you're a client of ours or here on the website, we'll be posting some information for that. But that seems like generally a good idea, just from the safety and standpoint of the community, not even from liability from crime, but liability from potential negligence, and just making sure that everybody is as safe as they can be. Next, they also say that training the employees of the association by January 1, 2025 is another step that you can take to have a presumption against criminal liability for criminal acts. And that also providing training to employees within 60 days after they are hired, starting January 1st, 2025. So there's a few more provisions in the law that discuss some of the implementations, but these are the nuts and bolts that I'm going to be recommending to all of my community association clients, and I recommend to all of you here who are board members or managers for community associations, look into these proceedings, because even presuming that no criminal act occurs on your property, and let's hope that that is a presumption that is a truth and doesn't happen, this really lays out a checklist of just good practices for doing what you can to keep your residents safe and operating in a way that really is in the best interest of the community.
Cindy, let me ask you something. If we go
Yeah.
back to the prior slide, John. Actually, the first slide, one before it. Okay, so the question of whether this applies at all to an HOA with single family homes. I mean, you can argue under the definition under 1B that it would not apply to a single family home community
Correct.
because it's not multifamily and it's more than one parcel. But what's interesting is with a townhome community that's under an HOA regime, each unit is on a separate parcel. So when it says consisting of at least 5 dwelling units on a particular parcel, arguably somebody can say even on a townhome community that's HOA that this statute wouldn't apply because it's not more than 5 dwelling units on a particular parcel. So the legislature, would you agree, has created some confusion on this. The other part is I'm a cynical person, but there are a few vendors that are going to profit from this particular legislation. That trading organization that is mentioned in the statute, certainly all of the security companies that provide cameras and so forth, anyone who does locks, they're all very happy right now.
Yes.
And Cynical B says that they may have been behind some of this legislation, but either way, there's going to be a tremendous benefit for them. So I think it will improve safety, but there's also it's pretty apparent that there was a profit motive in some of the particulars. But that's my cynical side.
And I agree with that, Alan, and also that this does benefit the insurance companies. Let's face it. Not even necessarily looking for the safety of residents, but thinking about the liability that insurance companies have. This will help them. And I do agree that applying this to townhomes is going to be a difficult analysis to make. We'll have to wait and see what the courts do with that. So I agree with your concerns.
Okay, John, and be sure, John, that you leave some time for me for my section here.
I'm going to go fast.
Okay.
I think we're on track. So another key piece of this legislation is that for the last, I don't know how many years, but it's been a while. And we're stepping back into the world of negligence for the most part. We're exiting criminal activity and injuries caused from crimes. But for a very long time, Florida was what was known as a comparative fault state. Comparative fault meant that in a lawsuit involving an accident where it may involve multiple people, the court, the fact finder, whether it's the jury or the judge, if it's a jury trial or a bench trial, in determining damages, has to apportion the fault of each party. So if I'm the plaintiff, right? Let's suppose I slip and fall in the lobby of your mid-rise condominium or high-rise condominium building, and I bring an action, a lawsuit, because of the condition that I said caused me to trip and fall. Well, if we went to trial on that case, the judge or the jury would have to determine how much I was at fault for that and reduce my damages by the percentage or apportionment of my fault for that accident. That was the law here in Florida up until recently. It still is essentially the law, but with one new wrinkle. The judge or the jury is still required to apportion fault. However, if I, as the plaintiff who am suing the association, if the judge or the jury finds me to be more than 50% at fault for that accident, then I don't get anything. It's a defense. It's a complete defense. Now, it's odd because 100 years ago, that was the law. Well, 100 years ago, if you were more than 50% at fault, period, you didn't win. But now, what they've converted Florida to is what's called now a modified comparative negligence state. The court still has to apportion the fault. If I was 10% at fault and my damages were $100,000, then I only get $90,000. But now if I was 51% at fault, I get nothing as the plaintiff. That's a pretty important change. So for you managers and board members, it's really important that if there's an accident on your property, you document right away, document the conditions, because that may be key to establishing that the person who is suing you for that accident, for their injuries, was more than 50% at fault. So develop procedures for accident investigation, accident documentation, photographs, whatever the case may be. But it's going to be crucial to do that right away after an accident, because you may be able to prove that that condition was so obvious that the person that got injured was being careless, and therefore they're more than 50% at fault for that accident. That's the takeaway there. All right, real quickly, I want to talk about.
Yeah, before you go past this point, the jury, if it's a jury trial, they don't know about this statute. So you're going to have a jury apportioning, and the anomaly is if a jury says that the plaintiff is 45% liable, they get recovery on the 55%. But if they're 55% liable, they get no recovery. And the jury doesn't know that there's this line of demarcation. So you're going to have insurance companies who are going to be defending more claims, hoping to get over that 50% threshold. It's going to decrease the payout on claims because they have this lever hanging over the plaintiff's head that we think we're going to be able to show the jury that you're more than 50% liable. So it's definitely going to impact the ability of people to get recovery for injuries because it's going to be tested. Go ahead, John. I'm sorry.
Okay. Lastly, there's a section that was directed at attorney's fees. In some cases, the winning party may be entitled to recovery of their attorney's fees. That's not the norm in Florida, but sometimes there are statutes which provide for that. For example, in I think it's 718-303 in the condominium statute, if a unit owner sues the association or an association sues the unit owner, that's an instance where the winning party might be able to recover their attorney's fees. And what we used to see in these attorney's fees applications is first the party seeking entitlement to their attorney's fees, their attorneys would provide the time they spent on the matter, the hours that they spent, all of the people in the office who spent time on that litigation, what their hourly rates were, and that would determine what's called a lodestar. The courts call it a lodestar amount. So it's hours times hourly rate. Is that reasonable? Most times, court's probably going to find that it's reasonable if you put in the right evidence and you have the right expert there. And that would be the lodestar amount. That's the amount of attorney's fees that the prevailing party, the baseline that they'd be entitled to recover. However, this whole body of law developed around this idea of multipliers. Sometimes they were called contingency multipliers. And so parties that were entitled to recover their attorney's fees would say, hey, our lodestar amount was X, $100,000. But this case was very, very complex. It would have been really hard to find any other lawyer other than our firm to do this case because of the complexity, the specialization needed, the unusual issues in the case. And so therefore, we're entitled to some sort of multiplier on that lodestar amount. And it might have been 1.5%, 2%, even up to 3%. And so what you had in these attorney's fees claims is this whole side issue where people were arguing over the complexity of the case, whether this required a specialist, whether there were other specialist lawyers who could have taken this in the geographic area. And so what you would see is attorney's fee awards that were getting, first of all, very complicated to litigate. And secondly, even though the amount of time spent was times hourly rate might have been $100,000, the court was saying, yeah, but this was a really complex case and there are not too many lawyers in Sarasota County who could do this. So we're going to do a 1.5 or 2 times multiplier. and increase those fees to $150,000 or $200,000. Well, the legislature has now effectively put a stop to that. In this new section, they've said that in most actions, the attorney's fees recoverable, when they're recoverable, is the court should consider, among other things, time and labor of legal assistants who contributed, non-clerical. I mean, it goes through this whole thing. But basically what the statute is getting at is the lodestar. What is the amount of time spent by the folks who were involved in litigating the matter for the firm, and what are their respective hourly rates? Now, here's the important part of this in sub 2. In any action in which attorney's fees are determined or awarded by the court, there is a strong presumption, not just a presumption, a strong presumption that a lodestar fee is sufficient and reasonable. Now, they don't foreclose the opportunity for contingency multipliers, but they say this presumption may be overcome only in a rare and exceptional circumstance with evidence that competent counsel could not otherwise be retained. So essentially what the legislature says is, unless you can prove that the firm that won this case is the only competent firm in the geographic location that could have done this, then there's a strong presumption, and it's very unlikely that you're going to get recovery of anything other than the lodestar amount without a multiplier. I don't know whether that's a good or a bad thing. I guess it depends on what side you're on, but that's what the legislature has decided here. So unless Alan or Cindy have any comments on that, I think we're going to turn now to Alan, and he's going to talk about construction defect claim reform, and then we'll take questions.
Well,
sorry, Alan, I'll switch to this slide.
I do know the next time I'm going first. Anyway, all right, so I'm going to be brief out of necessity. All right, so construction defect. This primarily applies to turnover situations where a condo or HOA has construction defects that they've discovered and how the time periods have been affected. But it also can apply to a repair job that goes wrong. So think of it in either context. So John, turn to the next slide. All right, the good news is for actions founded on the design, planning, or construction of an improvement to real property, there's still a 4-year statute of limitations. So everything that you heard about the negligence cause of action applying to accidents, if your accident is based upon, it's founded on design, planning, or construction of improvement, I would say that applies also to repairs. The 4-year statute still applies. What the legislature did is they altered the trigger point. So now it used to be date of actual possession, it used to be one category, they've taken that out. And what triggers the 4 years is when the authority having jurisdiction issues a temporary CO, a certificate of occupancy, or a certificate of completion for the date of abandonment, whichever is earliest. Now, here's the problem with the temporary certificate of occupancy. Some jurisdictions issue a temporary certificate of occupancy per floor in a high-rise building. So you have different temporary COs. How the statute is going to affect that? Would the statute be triggered earlier if one floor is given a temporary certificate of occupancy? Legislature, I don't think, considered that. So CO, temporary CO, really important to know what those dates are to determine the applicability of the statute. Okay, so what about a latent defect? And that's covered in this section. John, if you could, for a latent defect, the time runs from the time the defect is discovered or should have been discovered. And it used to be, years ago, it was 15 years that you had time to pursue a latent defect. The state legislature has reduced that over the years to 12, then to 10. Now they've moved it to 7 years. So even for a latent defect, the outside date is now 7 years from, again, temporary certificate of occupancy, which could cause some confusion, or the date of abandonment of construction, whichever date is earliest. There's a right after that time to bring a third-party action by the developer, but it has shortened that time frame. Now, here are the complications. In a condominium situation, you have 718-124, which says that a cause of action on behalf of a condominium association doesn't accrue until turnover. So what about a condo that has late turnover? 718-124 is helpful for the statute of limitations application. But for a latent defect, the 7-year period of time, 718-124 does not extend that. So if you happen to be managing or a board member on a condo where one of the early buildings was CO'd many years ago and turnover is delayed, you got to be very careful about acting and filing an action if necessary on that regarding that older building, because you can lose the statute. You'll see another section that we're going to see that's going to apply to that situation. So they have thrown a major disarray in, and this leads, again, it's really important upon turnover. If there's any opportunity for holding anybody accountable for construction defects, that you have that engineering study done as early as possible. And it may require with some communities that there be some sort of engineering study even before turnover. But we're individual owners within a community get together, find a lawyer, find an engineer, and do some sort of an engineering study even before turnover. That's going to cause that complication. Now, for homeowners associations, there's no 718-124 equivalent. So there's no savings for turnover. And this, again, for communities where developers have held control for many, many years, the applicability of this statute is going to be very troublesome. And again, there may be a need in communities that have delayed turnover HOA for owners to actually take some sort of action before turnover to preserve claims, because there's no savings clause written in this statute. Now, the end of this particular section, it says if construction is performed pursuant to a duly issued building permit and the authority having jurisdiction has issued a temporary CO, a CO, and so forth. You go on to the next slide, John. The performance of repairs does not extend the statute of limitations or the statute of repose. So be wary of when you're negotiating with the developer, if you don't have a moratorium agreement extending claims period, there may be a need to get your claim filed and then talk, rather than talk, wait for repairs, see if they work. Your time limitations may be running. Now, it's an interesting savings clause that the legislature stuck in here. If you happen to have bought, John, if you go back to that prior slide. Okay, if you happen to have bought the model home, you get an extension on the statute of limitations. So if it's used as a model home, the time period doesn't run until the date the deed is recorded. Now, how do you know you bought the model home? What if the developer's using several homes as a model home? But if you can determine that, you have a special savings clause. Okay, John, go ahead. I'm not going to try to explain this one. But the important part of it is that there is a time period, unlike the negligence cause of action, which required many personal injury lawyers around the state to move immediately and file a lawsuit before the commencement date of the act. There is a savings clause where if your statute of limitations would have run or statute of repose would have run because of this statutory change, you have until July 1st of 2024 to file your action. So there was definitely a savings on that. John, if you go on to the next one. Okay, one couple more things. I missed the statutory section for this. For multi-building properties, each building stands alone in determining the limitations period. So there was case law. We used to argue that in a multi-family property, condo or HOA, that it was the completion of the entire project which triggered statute of limitations, statute of repose. Legislature is now saying that each building stands alone. Well, Cindy, John, and I were perplexed by that because in a condominium, every portion of a building is part of the common elements. So again, in a property where it's a condo, one building is completed early, there's a length of time, maybe years before the other buildings are completed. Does this mean that pre-transition, somebody has to file a lawsuit for that first building, which has all kinds of practical implications because it's not a separate declared, it could be a multi-building condominium. So that has caused a lot of confusion. And the HOA side, what if a clubhouse was built 10 years ago? You're probably out under this new legislation. Whereas we had an argument before that time that it still could be pursued. Okay, finally we get to alteration to the building code section. So we had a really important statute in Florida, 55384. And it simply said when it was first passed decades ago, that anybody injured as a result of a building defect that constituted a code violation had a statutory cause of action against the party who caused the violation. And really important cause of action because a building code sets a minimum standard for construction. And it does in Florida incorporate or encompass most building components. So the Florida building code is a very strong building code. It adopts a lot of national standards, and most engineers in a defective building could find a building code violation that is applicable to that particular defect, or very significant cause of action in Florida. So what did the legislature just do? They added a word to it. Now it used to just say a result of a violation. Now it says material violation, and defines material violation as a Florida building code violation that exists within a completed building, structure, or facility, which may result or has resulted in physical harm to a person or significant damage to the performance of a building or its systems. So let's focus on that significant damage to the performance of a building or its systems. Now all engineers in writing defect reports are going to have to insert within their findings that each code violation that they've determined exists may reasonably result in significant damage to the performance of the building or its systems, which is a little bizarre from our perspective because, again, the building codes are minimum standards. So if the violation of a minimum standard doesn't result in doesn't reasonably result in potential significant damage to the performance of a building or its systems, then it probably shouldn't be in the building code. So to me, it's self-executing, but it's going to force engineers to go through this dance and use terminology that they're not used to using. Engineers don't talk in terms of significant or not significant. If you ask an engineer whether a building code section is significant, they will probably give the same answer that I just gave, that if it's not, if they put it in the code, it must be significant. And significant damage, not sure what that means. And again, significant damage to the performance of a building or its systems. If you go into engineering textbooks, this is not terminology that engineers typically use, but now they're going to be forced, when they're testifying at trial or a deposition, that there's going to be defense lawyers who are going to ask them that precise question. And all the engineers who do defect support are going to have to answer the question, yes, this code violation may reasonably result in significant damage to the performance of the building or its systems, and probably answer that question for every defect that they call out. So I don't know what inspired the legislature to adopt this. It may have been a particular contractor legislator who believes that they were held accountable for some, quote, technical violation, and they wanted to stick this portion in, but again, it complicates us and our job and things that we have to deal with. So the bottom line, and we're going to just have a couple minutes for questions, and we'll go on after the hour's over. Some good in the area of negligence, limiting owners' rights to pursue or guests' rights to pursue. Certainly, if there's a criminal act that occurs on your property, there are now better protections for community associations against liability. Construction defect lawyers are going to be, and general counsel are going to be telling you to watch those time limitations for pursuing defects, and we're going to have courses for the engineers who do defect work to now educate them about what they have to include in their report, so what they're reporting fit within this definition of what's a material violation. So there's going to be some interesting discussions there. Cindy or John, have you seen anything in the chat that we can respond to fairly quickly?
Well, it's been a pretty quiet chat this session.
Yeah, there were a couple of questions I answered, but may not have answered in full. One was regarding how the cameras would work realistically for the protection from criminal liability. And that is going to be the board's responsibility, candidly, to ensure that the protections are there. Asking an individual unit owner to do it as a volunteer might not be your best system. It might be well worth hiring some IT help to set up good backups and to set up the cameras. That's, I mean, it's like many things, you get what you pay for. So I think it's highly worth consulting professionals, and not even necessarily a security company. An IT company could potentially help with that. But asking an owner to do it is probably not going to work out the way you might hope.
If you're in an HOA, you know, we've long concluded that HOAs are the stepchild of community associations in Florida. Condominiums have some built-in protections. They have a statutory warranty. They have 718-124, which extends statute of limitations based upon the point of turnover. And there's a lot in the building code and in the statute that's tied to buildings what happens with an HOA is you have extensive site improvements. You have lakes, you have roadways, you have a clubhouse, you have sometimes extensive recreational facilities. The legislature's taken away implied warranties as it applied to those elements. You don't have the protections of extended statute of limitations, and especially in larger communities that are built over an extensive period of time. We just were involved in the turnover of an HOA master association 30 years old, which has over 7,000 units, 7,000 homes. And they have issues that have been, they have issues that impacted the community. And they say, well, what's our right to go back against the developer? Well, it's limited. One of the keys, and which we haven't discussed, is in an extended turnover situation is the pursuit of the developer for negligent maintenance, financial claims that may result, were sufficient reserves collected to cover the enormous burden that has now shifted to this association after all this time, where governmental regulations complied with. There are areas that can certainly be pursued, but from a warranty standpoint, an negligence standpoint, the developer, the legislature has done HOAs really no benefit, that's just. But there are means, and there are means for connected townhomes and so forth to get recovery, but they've made it a little difficult for us. So anybody, it's 12:01. Anybody have any other questions? So I guess we fit within the parameters. Well, everybody, enjoy your day. Thanks for coming on. This session will be recorded. It'll be on our website probably in a week with a transcript, so feel free to share it. And for those of you who have made your way back up north, enjoy the summer. Keep tuning in. We'll be here next month, probably to cover the glitch bill, and that should create quite a bit of interest, especially on the condo side. But we'll have something for HOAs also. So thank you, everybody. See you next month.
Bye.